Dear colleagues, let me introduce the chair of our first panel devoted to international trade law and sustainable development, His Excellency Ambassador Chad Blackman. Ambassador Chad Blackman is ambassador and permanent representative of Barbados to the United Nations and other international organizations at Geneva. He is chairing our first panel. Ambassador, the floor is yours. I hope that Ambassador Blackman is with us.
Yes, thank you very much. I am indeed here. First of all, let me say thank you to all of you, and in particular, Dr. Barry, for facilitating my participation in this very important meeting. And also, let me also say good afternoon to Professor, and for your very lovely keynote. Always very relevant and always a thought leader in the international trade community. So very much thank you. But as I was introduced just now, and the topic, as was mentioned, we're going to be discussing the reshaping of international trade law for sustainable development and focusing on the responsible production and consumption, gender equality, innovation, and climate change. Now, I think that this panel is very, very relevant, particularly given what's happening in the world. And I can also say, as chair of the Trade and Environment Committee in the World Trade Organization, and also as a UN International Gender Champion, these things are being discussed in the corridors of power, as it were, in Geneva in the multilateral system. So the discussions here, I can only hope, will serve to inspire and further shape what is taking place across the world, but particularly in Geneva. Now, in the advent of COVID-19, if there ever was a time for the global trade law and development communities to reimagine a global economy that is driven by sustainability, and underscored by production and consumption that is both responsible and resilient, with sensitivities to gender equality, climate change, and innovation, I dare say that that time is now. We have seen in a very short time, in the last few months in particular, how vulnerable our economies are and the impact on our country's ability to provide stability in these circumstances. Equally, the issues of ensuring that as we rebuild and doing so in a more sustainable way is even more critical. This, however, presents us with a number of unique opportunities. And I always say whenever I can, we should never waste a good crisis. Areas of the circular economy, addressing issues of the plastics and pollution, fossil fuel subsidies, and ensuring that the global private sector is on board in innovative ways will be key in ensuring that all of the above is achieved. Now, obviously, this is happening at a time when the world's chief regulator of international trade, the WTO, as you would have heard, is having its own number of issues, particularly in the appellate body, and having the inability to have judges be appointed. So this discussion is taking place, as I said, within that context, and therefore we have a very distinguished panel here to unpack many of these issues and build upon Professor's keynote remarks this afternoon. So we have a number of panelists, as I mentioned to you, and just to introduce our first panel, I will do so. Each panelist will be given 8 minutes, and then we will go to the other. And at the end of that period, we will have a number of questions and answers. I'm not entirely sure if the facility is here where persons from outside of the panel can be asked questions. But equally, if you have any questions, I would suggest that you drop them into the chat box, and then we will take it from there. So, without any further ado, I will introduce our first panel, Dr. Michael Riesvas. Now, Dr. Riesvas is an assistant professor at IE University Law School, specializing in public international law, WTO law, and international arbitration. Prior to joining the university school, Dr. Riesvas was a postdoctoral research at the University of Amsterdam, working on an ERC project on domestic law in private-public international arbitrations. Now, he's included in the list of arbitrators of the Court of Arbitration for Art of the Netherlands, Arbitration Institute, and the Common Court of Justice Arbitration of the Organization of Harmonization of Business Law in Africa. Ladies and gentlemen, without any further ado, I introduce to you Dr. Michael Riesvas.
Hello, I hope you can see me and more importantly, hear me.
Yes, loud and clear.
Let me start by, first of all, thanking the organizers for this excellent initiative. Thanking on my part, Professor Van der Bosse for his amazing keynote speech. And of course, thank you very much, Ambassador, for your very kind introduction. Given that my time is rather limited and I was given the task to present on cryptocurrencies, I will try to be as brief as possible in order to allow time for our discussion at the end. In the meantime, I'm trying to share my my screen. I don't know if you can, if that's working for you. Maybe not.
Not yet. We can't see your screen. Are you able to share it? Yana, do we have the rights to share directly, or would you?
Yes, yes, all the co-hosts should be able to share it.
I've just edited the feature, I think, from here, so possibly I think you might be able to do that.
Or perhaps I can upload the presentation on the chat. That would be easier, perhaps, because I cannot. Let me.
Do you have a share screen button at the bottom of your screen?
Yes. Now it worked. I don't know why it was not working before. So I think you can see now the presentation. Perfect. So I'm going to speak for the next 6 minutes, I hope, on a very topical but complex topic at the same time: the World Trade Organization, the concept of monetary sovereignty, and the issues of cryptocurrencies. So I will briefly address 5 main issues. The first is I will very briefly explore the cryptocurrencies revolution that has taken place over the last few years. Then I will focus on the importance of the correct and appropriate legal classification of cryptocurrencies. And in particular, I will explore whether cryptocurrencies should be legally classified as currencies, as goods, or as services. And I will explain why this classification has important, profound legal implications. Now, most of you, you will be already familiar with the concept of cryptocurrencies. I have included here 2 definitions, one from the Oxford Dictionary, which traditionally remains an authoritative source. So cryptocurrencies are defined as a digital currency in which encryption techniques are used to regulate the generation of units of currency and verify the transfer of funds operating independently of a central bank. That last part of the definition is of significant importance, and I will come back to it later. I have another definition given by the European Commission, not very dissimilar from the definition I just gave. And again, I quote, "Cryptocurrency is a digital representation of value that is neither issued by a central bank or a public authority, nor necessarily attached to a fiat currency, but is accepted by natural or legal persons as a means of payment and can be transferred, stored, or traded electronically." You can see on the right part of the slide a very basic diagram which visualizes the decentralized nature of cryptocurrencies. Perhaps the most famous cryptocurrencies is the Bitcoin that we all are to a certain extent familiar with, and indeed the decentralized nature of the system of cryptocurrencies is perhaps the defining characteristic of it. Here I have another diagram which attempts to classify different related concepts, delineating the boundaries between digital currencies, virtual currencies, convertible currencies, decentralized currencies, and cryptocurrencies. Unfortunately, I don't have the time to go into detail, but I wanted to have this slide to project and highlight the complicated universe of cryptocurrencies, which I have to say is a continuously expanding and evolving universe. Now, the legal classification of cryptocurrencies, as two authors that wrote a paper on the subject last year accurately observed, the issue of classification is a threshold question because it is central to the treatment of cryptocurrencies at the World Trade Organization, and I would add at other international fora. Essentially, the legal classification will have a significant impact on the applicable regulatory framework. In other words, how we classify what is a cryptocurrency will determine the rules and regulations applicable to it to a very large extent, at least at the international plane. So if we view cryptocurrencies as their name suggests as currencies, then the appropriate forum for their regulation is the International Monetary Fund. If we determine that cryptocurrencies are goods, the appropriate forum is the World Trade Organization, and the appropriate instrument is the General Agreement on Tariffs and Trade. On the other hand, if we determine that cryptocurrencies are essentially a service, then the forum is again the same, the World Trade Organization, but obviously the instrument, the international treaty which will regulate cryptocurrencies will be the General Agreement on Trade in Services. I will come back in a minute on the differences between these two instruments. So, cryptocurrencies as currencies. Part of the answer to whether cryptocurrencies are currencies has to do with whether we adopt an economic, purely economic, or a legal conceptualization of money. The economic perspective in all classic monographs about money, money has four essential characteristics. It's a unit of account, means of payment, means of exchange, and store of value. But if we move in the legal realm, and I have here the classic definition by Francis Mann, money has to have certain other qualities. It has to be issued under the authority of the law in force within the state of issue, under the terms of that law, denominated by reference to a unit of account, and under the terms of that law, money has to serve as the universal means of exchange in the state of issue. It has to be legal tender. So in order for a particular instrument to be classified as money, it has to have a sanction from the central authority, from the central bank, which, as we saw in the introduction, is missing from cryptocurrencies. And therefore, recognizing cryptocurrencies as currencies without any state to date officially recognizes cryptocurrencies as a national currency would go contrary to the concept of monetary sovereignty. Now, monetary sovereignty is a very complex concept which has many aspects, but the most important aspect of it is the right to create money. And you can see a recognition of that right in an old Permanent Court of International Justice decision from 1929, where it is stated that it is indeed a generally accepted principle that the state is entitled to regulate its currency. And other authors also think that it is a bad idea for policy reasons to have the IMF regulating and supervising cryptocurrencies, because that will legitimize cryptocurrencies. And by contrast, the WTO has better mechanisms, tools, fora, and institutions to supervise that. Now, here I have to open a parenthesis, given the current legitimacy crisis of the World Trade Organization, but given the fascinating tour of that issue by Professor Van den Bossche, I don't think I will need to add anything on that front. Now, cryptocurrencies as services, there is a trend towards that, the recognition of that conceptualization. I have here a case from the Court of Justice of the European Union which goes toward that direction. There is also the ongoing dispute between Venezuela and the US. Obviously, this is a very complicated dispute, but part of the request for consultations by Venezuela of 2018 focuses on trade restrictive measures imposed by the US in relation to the Venezuelan issue, to the cryptocurrency issued by Venezuela. Naturally, under WTO law, a certain measure can fall within the scope of both the General Agreement on Trade, on Tariffs and Trade, as a good, and under the scope of the GATS, of the General Agreement on Trade in Services. And you can find a recognition of that principle in paragraph 221 in the classic EC Bananas appellate body report. Essentially, in order to determine whether GATT and or GATS are applicable, we have to adopt an ad hoc case-by-case approach. However, as I will argue, the GATT constitutes a more robust and comprehensive and mature framework for regulating cryptocurrencies, because the General Agreement on Trade in Services within the framework of the WTO was a product of a compromise. And therefore, it is structured on the basis of a variable geometry. For example, while you have some general obligations such as the MFN, market access and national treatment obligations, which are very important obligations in the field of international trade, are conditional obligations and depend on specific commitments undertaken by different WTO members. Therefore, the better view is, and this is something that is shared by states such as Canada, but also by authors such as Howden, the better view is to accept that cryptocurrencies, as things currently stand, and this is a very important caveat because a regulation can change everything from one day to another, as things stand, the better view is that cryptocurrencies should be considered as barter transaction, exchange of goods or services for exchange of other goods, and there should be primarily, although not exclusively, be regulated and assessed under the General Agreement on Tariffs and Trade, which is, one could say, and I will end on that note, perhaps from an adjudication perspective, at least until today, one of the most successful international treaties. I'll stop here because I want to preserve as much time as possible for any comments or questions that you may have, because that would be really interesting. Once again, thank you very much for this opportunity, and it was a great pleasure to share my thoughts on cryptocurrencies with you. Thank you very much.
Thank you very much, Mikhail. And now we're going to move to our second panelist, Cristina Poncibo. Now, Cristina is an associate professor of comparative private law at the Department of Law of the University of Turin and fellow of the Center for Comparative and Transnational Law. She's also a fellow of the Turin School of Development and a member of the Scientific Committee of the Master of International Trade Law there, with Citral and Unidwart. Equally, she holds a degree in European private law from the Faculty of Law of the University of Turin, and a PhD in comparative law from the Faculty of Law, University of Florence. So, ladies and gentlemen, without any further ado, I introduce you to Cristina Poncibo.
Okay, I hope you can hear me and you can see me.
Yes, perfectly, yes. Both, absolutely.
Great. I'm also trying to share in my screen my handout. I hope you can also see it.
Yep, it's all there.
You can see it? Oh, fantastic.
Yes. Perfect.
So, first of all, I would like to thank the organizers for this very, very interesting conference, and also for the hospitality granted to a comparative private lawyer, because my field is comparative private law, and my presentation and my paper concerns the private side of SDGs. So the role of private actors in rethinking, repackaging world trade with a focus on sustainability. I mean, I try to be, as my colleague before, very short, because the time is rather limited. So I propose to you to discuss 4 research questions. The first is how private actors are contributing to advance SDGs in world trade. And my focus is about codes and mainly on contracts along the global value chains. And my second question is about the focus about contracts. And so the practice that is becoming more and more frequent along global value chains to include sustainability goals as part of agreements with suppliers and sub-suppliers by multinationals. And this practice consists in or repeating certain provisions of codes of conduct and try to contractualize the obligation of respecting sustainability along the value chain, along the suppliers chain. So if we consider to find a sustainability contractual clause in a supply chain contract, what kind of value we can give to this kind of provision. And obviously there is a further question, do contract contribute, do these kind of clauses have an impact in advancing sustainability goals? So my first research question is dealing with the interplay of the public and the private dimensions in advancing sustainable SDGs, Sustainable Development Goals. I used to discuss with my fellow friends in public international law about this interplay. I mean, we discuss quite often about the public international law provisions, guidelines, soft law, trying to invite, could we say invite, multinationals to step in and to try to use private means to advance SDGs along the global value chain. So it's about the interplay between different actors. For us, for people in my field, this is quite an interesting topic because it's like that you try to transplant, according to the theory of legal transplants in comparative law, values such as the respect for the environment, the respect of, employees, and the many diverse goals in the global value chain, in the production system, and you are trying to transplanting certain values by contract. That is quite unusual because usually you try to transplant principles by law, by statutory law, not by contract. So it's a sort of way of promoting justice by contract. But could you reach public goals by private means? But because this is about also the blurring divide that this is disappearing in world trade in between public and private dimensions. For us, the question is, are we discussing of contractual provisions that are binding and enforceable? Because obviously this is the most important question. We know, and in my field is well known, the limitations of the codes of conduct. Codes of conduct has been widely explored by colleagues and scholars in different disciplines. Why they can contribute, we have seen the many shortcomings, especially from the perspective of contract law, in trying to enforce the vague and provisions of codes of conduct before a judge, for example, or in arbitration. So the process of, putting such provisions in contracts with suppliers Is it creating binding obligations? In my analysis, I tend to distinguish an internal dimension, obligation between the parties, and an external dimension, that namely third-party enforcement, the role of third parties. If we reason in classical contract law, scholarship, the answer is that is it really difficult to enforce sustainability contractual clauses. Difficult because the rules concerning termination for breach of contracts, the rules dealing with the conformity of the goods, and also the rules about the possibility of claiming for damages by the multinational because the damage to reputation in case any supplier is polluting or is not respecting a shared values in the World Trade Community. These typical remedies in contract law are not designed to deal with public goals. So it is hard to say that there is a lack of conformity because the good has not the promised qualities, but the qualities dealing with respecting values and advancing rights. Usually you think to defects that are, concerned with the quality, the formal and the quality of the goods, not with the lack of respect of ethical values in the production of the goods. The same for termination. Do you think that such kind of clauses are fundamental in the contract? If so, you can discuss, you can apply termination if rules, if not. So private law remedies have not been designed for public goals, and this cause problems in between the parties. But this external dimension is much more complex, and it shows many shortcomings more than the internal dimension, in the sense that every contract law scholar can tell you easily that contract is binding for the parties. This is, the dogma now. So it means that it's very difficult for a third party to claim for rights on a contract as a third party. But we are seeing quite interesting developments in the case law dealing with the role that a local community or an NGO or an association could play with respect with investment contracts, for example, or contracts that concern natural resources, or contracts that have a strong impact on local communities, where you can define the local community at issue. We see that there is some sort of possibility of claiming on the basis of a contract in case of breach, but very limited, because the main principle is limited to the parties. So at the end, the conclusion would be, if it's so difficult to enforce such clauses in both the internal and the external dimension, what they are for? Are they really useful, or these clauses are just a way for the multinational to protect reputation or to signal to suppliers and sub-suppliers certain values? Do they have an impact at the end? My analysis, my impression in writing and researching on that is that you can see the impact not if you look at the formal private law remedies, but if you look at relational contract remedies. There is a sanction in case of breach of sustainability clauses, but the sanction is based on the community of traders, is based on World Trade as a community of players. It means that if a supplier breaches the sustainability clause, by polluting, by breaching rights, the reaction is informal, and it could amount to a sanction that means we do not do business with you anymore. So you can be included in a blacklist. You can be subject to a corrective action plan. So it's the community that is reacting with sanctions that are more based on practical aspects, but for a supplier, being in a blacklist, not doing business anymore is a very strong sanction. These kind of sanctions have been also included in contract law theory under the relational theory of contract that is stressing the role of the relationship among the parties as a key driver. So basically, the impact is based in the community itself, in sanctioning, in reacting. So a second point I would like to raise, it is difficult to see an ex post litigation quite often with respect to such clauses, but because this kind of clauses, they favor a sort of shift towards an ex ante perspective based on training, monitoring, auditing, preventing the risk of the breach. So there is also this shift from ex post litigation to ex ante perspective based on these tools. Conclusions. What is really interesting here to me is this hybrid system that we can observe. That is a system that international organizations are promoting by soft law guidelines, a number of tools that you know perfectly, by inviting, I would say by delegating, but this is questionable, it is a good point for discussion. They invest private actors to be part of an hybrid system to effectively pursue SDGs goals. So my point, if we would like to get an understanding of this practice that is becoming more common within traders, we do not, as contracts law scholars, not focus only on the formal enforcement, that is still very important. The shadow of formal enforcement is always relevant, but if you would like to understand how it works in this specific case study, our focus should be much more sociological. That means looking at sanctions from the perspective of the community of world traders. And a final point, I would like to give this hint for the discussion. If the community of traders is more and more sanctioning misbehavior by excluding someone or by developing systems of blacklisting or corrective plans, this means that the community or the majority of the players, they think that SDGs should be respected in private business. If there is a sanction, does it mean that the respect for SDGs is becoming to be part of the lex mercatoria? Because as you know, when you have a trade usage, it is because the community consider this usage as something that the community should respect, and there are sanctions for misbehavior. If we are sanctioning, don't you think that there is room for a discussion about a future development in what we mean for lex mercatoria to include certain SDGs, especially those related to sustainable production? This is quite an open point for the discussion. So these are my conclusions, and I really thank colleagues for the hospitality, and I'd be pleased to discuss with you of the interplay of the public and private side of SDGs as a new development in world trade law. Thank you. Thank you so much.
Thank you very much, Christina, for your intervention. And I'm particularly interested in the Q&A section to unpack the whole aspect of the hybrid law, looking at the marriage between the contract and the soft law through PIL. Now, at this time, we're going to move to our third panelist. We have Dr. Daria Boglan. Dr. Boglan is a professor of international law at the National Research University Higher School of Economics in Moscow in Russia. Professor Boklan was a member of the expert group drafting the Treaty on Eurasian Economic Union in 2013-2014, and equally is the author of 2 books on international environmental law and international economic law, and more than 50 scientific publications in international environment law, law of the WTO, and law of Eurasian Economic Union. Therefore, ladies and gentlemen, it gives me pleasure to introduce to you Dr. Boklan. May I also take the opportunity to remind panelists that we have a very strict timeline, and 8 minutes, including when you give your initial introduction, is counted in the time. So, Dr. Boklan, the floor is yours.
Yes, I'm so sorry. I'm struggling with technical issues. So please let me know if I share the screen. Okay, thank you.
Yes, please proceed.
Yes.
Yes. Something wrong with my. Okay, so let's do it in this way. So thank you very much, Ambassador Blackman, for this kind presentation. And my presentation is devoted to interconnection between international trade law and international climate change law. My research question is, may WTO agreements and Paris Climate Agreement supplement each other to fulfill both trade liberalization and combating climate change objectives at the same time? To answer this research question, the following reasons show the significance of answering to this research question. First, taking urgent action to combat climate change is one of the Sustainable Development Goals. Second, there is no responsibility under international law for the harm caused by climate change. Third, most states are parties to both WTO agreements and Paris Agreement. And finally, there is a risk of carbon leakage. That is a situation when economic activity shifts to less carbon constrained jurisdictions. As a result, greenhouse gases emissions would not be reduced, but simply shifted to other national jurisdictions. So assessing these issues, I would like to propose answering to the following questions. First, can WTO agreements and Paris Agreement be applied in the context of each other? Second, if 2 physically identical products are produced with different level of greenhouse gases emissions, can they be treated differently under WTO law? And finally, is it possible to use WTO instrument to comply with the Paris Agreement obligations? And if yes, which particular instruments can be used? So moving to the first question, I would like to underline that on the one hand, the Paris Agreement stresses that measures taken to combat climate change, including unilateral ones, should not constitute means of arbitrary or unjustifiable discrimination or disguised restriction to international trade. On the other hand, as it was underlined by the appellate body, WTO agreements cannot be read in clinical isolation from public international law. Therefore, our first conclusion that in theory, WTO agreements and Paris Agreement can be interpreted in the context of each other. But to put this theory in practice, we have to answer the second and the third question of my presentation. Moving to the second question, I would like to underline that notion of production and process methods is broadly understood nowadays, and it includes actually any policy which connected with placing product into the market, including climate change policy or policy aimed at fulfillment of objectives of the Paris Agreement. There are 2 kinds of PPMs, so-called product-related PPMs, which leave the trace in the product when it is consumed. This product during the consuming pollutes the environment. And second type, the ppms which do not leave any trace in the product, meaning that they harm environment only in course of the production, for instance releasing of different pollutants into the air. Therefore, the question we should answer, will it be possible to maintain the two physically similar and competing products are nonetheless unlike, basing on greenhouse gases emissions, since this is not a product-related criterion, but rather criterion which exclusively relates to the process and production. Turning to the jurisprudence of the WTO, I would like to remind that the appellate body compared likeness with an accordion, and the eyesight which stretches and squeezes in different places and as different provisions of the WTO agreement are applied. And the appellate body added to this that this term must be interpreted in the context and the light of the object and purpose of the provision at issue. Preamble of the agreement establishing WTO contains objective of sustainable development and protection of the environment. Moreover, several agreements, for instance, technical barriers to trade agreement, provide for environmental protection as one of its legitimate objectives. Therefore, it is possible to include non-incorporated ppms, which do not leave any trace in the product itself, into assessment of likeness of the products depending on the level of greenhouse gases emissions. In addition to this, as soon as consumers' tastes and habits are considered by WTO jurisprudence as one of the likeness criteria, it is very likely that consumers would prefer products physically same, but with less or without any greenhouse gases emissions during the course of its production. And this decision and this characteristic of the production even could be decisive for consumers to prefer one product over the other. This is also can be relevant because GHG emissions are connected with different kinds of risks important for consumers, including health risks. Therefore, there are no legal grounds for the dispute settlement body to reject the ppms connected with the Paris Agreement objectives in the determination of likeness of the product under the WTO. And now, finally, moving to the last question about possible instruments which could be used to fulfill Paris Agreement objectives. There are several of them, therefore the answer is positive. First, Article 20 of the GATT, which enshrines general exceptions, namely exception G, measures related to the conservation of exhaustible natural resources, and paragraph B, measures necessary to protect health. Article 3 of the GATT with respect to carbon taxes, technical barriers to trade agreement with respect to carbon labeling, and subsidies and countervailing measures agreement with respect to technologies aimed at fulfillment of Paris Agreement objectives. Due to the lack of time, I will focus only on the two aspects of the first instrument, Article 20G, and would kindly refer you to my draft paper for the further analysis. So, to assess this issue, I would like to answer to the following questions. First, could climate be considered as exhaustible natural resource? And second, may measures aimed at fulfillment Paris Agreement objectives by their nature fall under Article 20G of the GATT? So answering the first question, the appellate body noted the term natural resources in Article 20G is not static, and its content by definition evolutionary. Moreover, clean air was considered to be exhaustible natural resource by the panel in US gasoline case within the meaning of Article 20G. Therefore, it is likely that climate would be considered as an exhaustible natural resource under Article 20G. Answering the second question, I would like to underline that climate is a global common and shared by all states' natural resource. Secondly, greenhouse gases pollution has transboundary nature. Therefore, Similarly, as it was done in US totals by the appellate body, when the appellate body found a sufficient nexus between migration and endangerment of the sea turtles for the purposes of Article 20G. Greenhouse gases emissions migrate and carbon regulation on inputs would fall under Article 20G of the GATT. Hence, Article 20G could be invoked as a ground for justification of the measures aiming at fulfillment of the Paris Agreement objectives. And finally, my pre-conclusions are the following. Measures aimed at fulfillment of the Paris Agreement objectives have strong connection with the WTO legal regime because they influence process and production methods of the products. And secondly, WTO agreements could be effectively used in order to achieve both objectives of trade liberalization and combating climate change at the same time. So let me conclude with these pre-conclusions, and thank you very much for your attention.
Thank you very much, Dr. Boklan, for your very enlightening remarks and presentation. And I'm particularly interested in hearing more in terms of getting member states to understand the nexus between the Paris Agreement and the legality of those instruments and the WTO, and how do we get that mainstreamed through the World Trade Organization, particularly now where there's a lot of discussion on WTO reform and the retooling of the Marrakesh Agreement, and how can that be fit into that matrix. So you can quietly prepare your mind for that question when we come to the question and answer segment. Now, at this time, ladies and gentlemen, I'm going to introduce our fourth speaker, who is Dr. Amrita Barry. Dr. Barry is an assistant professor of international trade law at ITAM in Mexico. She's also the co-chair professor for WTO Chairs Program Mexico and an international consultant for trade and gender at the International Trade Center here in Geneva. And I would also say that some of her work was recently instrumental and pivotal in some of the offerings that the International Trade Center would have done with in partnership with Dr. Barry. So in light of that, and given the context of what we're discussing, I will now give the floor to Dr. Barry to make her presentation.
Thank you, Ambassador Blackman, for the opportunity. And I hope you can see my presentation. Yes?
Yes.
Okay, great, thank you. So the focus of this presentation is going to be on Sustainable Development Goal 5, gender equality. And we will try and see how we can combine the two, how we can try and make gender equality at one end and international trade on the other end interact. In the next 5 minutes, I will first present my thoughts on how interaction of trade and gender equality, or how gender equality is no longer a social issue, but a very much economic issue or a business case to present. And that prepares a case for why we should be using trade policies and trade instruments to achieve gender equality. The second is the approach, how we can go ahead with ensuring that we are advancing gender equality using international trade law principles. And in there, I will be presenting a framework that I have prepared working with ITC, which was published last week indeed. And I'll conclude with some results. So what happened and what did we find in terms of how responsive gender agreements or trade agreements are all across the world when we applied this framework to the existing free trade agreements. So I think it is important to start with the observation that even though some trade law community and some trade stakeholders may argue that trade and gender are two separate issues, I think they could not have been more intricately related ever than they are now, especially when we are living in a pandemic, and we will soon be making a recovery, hopefully, fingers crossed, out of this pandemic. And we will be wanting to reboot our economy. We will be wanting to rebuild what we have lost in the last 1 year or in the last few months. So the question is, how do we reboot our economy if we are not including, if we are not connecting half of the world's human kind or half of the world's workforce in the process of economic growth, in the process of economic development? It is not possible. So I think we have to connect women back to the economy, mainly because this pandemic is having a disproportionate harm or a disproportionate effect, even related to gender. So it is having a way more impact, negative impact on women in economy than men. And gone are the days when gender equality was only considered as a social or a moral case. Now it has a business case. World Bank, it had to happen now, right? So World Bank, IMF, and McKinsey have come up with these numbers, and these numbers are eye-opening. These numbers show us that if we connect women to the economy and if we achieve gender parity by 2025, world's economy will be richer by more than 12%. And that is huge. And we need that right now when we are experiencing a global meltdown of economic growth. And this interrelation between international trade and gender equality has been recognized in various international instruments. It is Goal 5 of the UN Sustainable Development Goals. World Trade Organization, about 70% of the members of World Trade Organization came together and signed the very first declaration on trade and gender in 2017. ILO Convention 100 and 101 are focused on gender equality and economy, and the list goes on. So this is not a new development. If we look at the free trade agreements in the last few years, it is quite surprising to see that back in 1992, free trade agreements started to include provisions on gender commitments, explicit gender commitments. But that trend has gone really high. So in the last 2 years, 2018 and 19, we have seen some very ambitious trade agreements coming into force. One between Canada and Israel, which I think is the most gender responsive provision countries have signed so far, with very ambitious gender commitments on cooperation, on access to education, on women's access to technology, and so on and so forth. So if we dig deeper, what we find is that in the last decade, we have achieved quite a lot of progress. But if we compare the last decade in terms of how members or countries have been including gender commitments in their trade agreements and trade policies, there are quite disturbing numbers and stories going on here as well, as you can see. So we see that there is a prominent progress made in the Americas, and Europe has pretty much remained the same, but we see some kind of regression in some regions. We see some regression in the African continent, we see regression in Central Asia. So we're not sure what's happening, right? Why were countries including gender commitments 10 years ago, and why they have stopped including these gender commitments in their trade policies and trade instruments now? What has changed? Well, we can blame it on many reasons, but one of the reasons for sure is lack of awareness and lack of understanding on how trade and gender relate to each other, how they interact. So we have recently at International Trade Center, which is a division of United Nations, we have come up with the first ever framework, with the first ever toolkit to measure gender responsiveness of trade agreements. And this can make trade policymakers and trade negotiators more aware and more informed as to how they can go about negotiations and make and draft trade agreements and trade policies in a gender responsive, gender considerate manner. I don't have time to get into the framework, but it's available at the International Trade Center's website. So when we apply it to the existing trade agreements, what do we find? Well, we find that we have many agreements that include explicit gender commitments, but they are included in very diverse, very different ways. So the focus of gender provisions in agreements signed by countries in the Americas is most on access to education, access to women business opportunities, and so on and so forth. And they treat women as employees as well as business stakeholders. But if you move to European Union, the focus in European Union's agreements are more on protecting lives of women in conflict-like situations and against violence and access to health, which I think becomes so relevant now where we are witnessing massive rise in violence against women, household responsibilities, and reduced access of women to health services. So what lacks in all these agreements right now, we see that the situation as of today is quite promising, but there are three major things that these agreements today are lacking. The first is enforcement. All these provisions and promises are drafted as promises. They are not legal obligations. The second is implementation. Most of these agreements do not create any implementation mechanisms to ensure the implementation of these promises. And third, finance. Members do not, in no trade agreement, talk about how these gender commitments will be financed. Without money, these promises will always remain promises. Thank you.
Thank you very much, Dr. Berry, for your presentation as well. And I'm particularly looking forward to, in our Q&A section, for you to share with us some of your insights and the framework in which you would have created, which the International Trade Center is now using as part of its offering in terms of trading to this issue. So thank you very much for your presentation. Now we are going to move to our next panelist. As I told you, we have a huge lineup of experts here in this area. And we're going to move to Luana Almeida, who is a Brazilian lawyer and holds a master's degree in globalization and law, specialization in international trade and investment law from Maastricht University in the Netherlands. Now, having previously worked as a trade and sustainability consultant and as a corporate social responsibility specialist, she's now currently a Blue Book trainee at the DG for Development and International Cooperation at the European Commission. Luana has also published articles about investment law and WTO law. So, ladies and gentlemen, I give the floor to Luana Almeida.
Hello, everyone, and thank you for the introduction. My name is Luana Almeida. It's a pleasure to be here. And today I'm going to talk about my working paper, which is entitled The EU Green Deal and International Trade Law, Bringing Trade and Sustainability Together. The objective of this paper is to answer the following question: to what extent is the EU Green Deal in line with the European trade law framework? The outline of my paper is the same one as the outline of my presentation, considering that this part is already the introduction. So I start directly answering the question: what is the Green Deal? The Green Deal is the blueprint for the European policy for the upcoming years. It was launched in December 2019, and it already unfolded in several different papers, strategies, rules, and its objective is the achievement of climate neutrality by 2050. It allows the use of different policy levers, including using trade policy as a key element for EU's ecological transition. And it also foresees that the EU will use its power and political influence to become a global leader for sustainability. And what is the European trade law framework here? We think about the network of trade agreements that the EU created through the years, several as we can see, and also the role of the EU as an active member of the WTO, especially when we think about the disputes. And it's because of this relevance of the WTO and of the EU as a member that all the measures that they bring at the Green Deal concerning sustainability that might affect trade, they mentioned that they will be WTO compliant. And this is exactly the topic of my next section. This section, I took 3 measures that are mentioned in the Green Deal, and I analyzed how, if, and how they can be compliant with the WTO case law, analyzing, comparing with previous cases. The first one is a restriction to imports due to the presence of pesticides or antibiotics, so concerning agriculture. The case that I analyzed made a parallel with was EC asbestos. This case is especially relevant, as Professor Daria Bachman already mentioned, because in this case, the appellate body decided that consumers' habits can be considered for the likeness test. So if a product is different because it has asbestos or because it doesn't have asbestos, a product can also be different because it's organic or not. Besides that, in this case, the appellate body also understood that restrictions based on health concerns are justified. So one can also argue that restrictions based on environmental concerns can be justified. The following measure that I analyzed is a requirement for packages to be recycled or reusable. Another case that a country imposed a barrier to the entry of a product based on its effect on the environment was Brazil tires. In that case, the appellate body understood that the measure, the ban, was reasonable according to the level of protection aimed. So if we think that with the Green Deal, the level of protection is already very clear, is a virtual zero tolerance to single-use packages. So to impose a requirement can also be a reasonable measure if we consider the precedent of Brazil tires. The third measure that I analyzed has a softer language. So we're not talking here about a ban or a restriction. We're talking here about an incentive to products not linked to deforestation. So it's very easy to make a link to US tuna, because in that case, we were talking about a label stating that the product was dolphin safe. And in that case, the appellate body understood that differentiation based on process and production method is not per se discriminatory. So if we say that the EU is imposing a different treatment to products based on its relation to deforestation, it is not per se discriminatory. Besides, in that case, the appellate body also understood that it was a legitimate objective. What I aimed to show in this section was that the measures, when they are well written and they have a legitimate objective, they can be WTO compliant. But besides that, we also need to think about the picture outside the WTO. As Professor Peter van der Bosch mentioned, the appellate body is facing a paralysis. So what the Green Deal clearly is mentioning is the aim of creating green alliances, of bringing like-minded countries together to promote bold measures in favor of sustainability. And the main measure took by the Green Deal was to make the Paris Agreement binding in all the new EU negotiations. So, as also Professor Daria Bachman mentioned before, the Paris Agreement has already 189 ratifications. It will virtually affect every trade agreement. So what the EU has created is a framework that allows for sustainable actions to be taken without violating trade agreements. This leads to my final conclusions, that are that exceptions contemplating environmental policies were foreseen, even though the WTO agreements are older. And Canada and appellate body have been applying them in manners that allow for legitimate concerns to be implemented. Besides, outside the WTO, green alliances will allow the EU to build business partnerships focused on sustainability. Therefore, when answering the question, to what extent is the Green Deal in line with the European trade law framework, I would say that it's very much possible to implement the measures foreseen at the Green Deal without breaching the European trade law framework. In one hand, because the WTO previous case law gives a way to do so, and on the other hand, because the EU is shaping its network of agreements to allow that as well. Thank you for your attention. I'm very much looking forward to questions and to our debate.
Thank you very much, Luana, for your presentation, and also looking at the whole aspect of climate neutrality and its relevance as we go forward. Now, I'm acutely aware that we are actually running out of time, so I'm going to go straight to our next presenter. Nicolas Cobo Romani is a Chilean lawyer from the Universidad Católica de Chile with a master's in international trade from Universidad de Barcelona in Spain, and also has a Doctor of Law from Universidad de Salamanca, also in Spain. From 2012, was a founding member of the Latin America Observatory of Right to Food, and is a professor of international law at Universidad Católica de Chile. Ladies and gentlemen, I give the floor to Nicolas Cobo Romani.
Thank you, Ambassador. I'm sharing the PPT. I hope you can see it.
Yes, we can.
I'm going to surprise you. Maybe I'm going to propose something different and the contrary of Professor Peter van den Bossche. Maybe adding new restrictions to certain markets. In this case, is based on a particular reason. So the restrictions on ultra-processed food and drinks. So why? Because we have a huge problem. About 1 billion people suffering hunger, 2 billion suffering overweight and obesity. And this present data is probably worsened due to the COVID-19. This is preliminary data shows that already we has worsened these existing numbers. But the right to food is not commonly known by lawyers, but it's a human right. It's recognized in the Human Rights Declaration, and is included in certain international commitments, such as the Committee of Economic and Social Cultural Rights, General Comment number 12. This is not the only one. I'm just highlighting that there is existing obligation and recognition of the right to food, access and produce and buy good quality food. And it's also related to the sustainable development. And in this case, I can quote Professor Peter van den Bossche. He mentioned in his presentation rules on developing countries and effective S&D treatment. This is also related to this challenge. So what is the challenge? This is the Chilean situation. We have 74% of the population with problems of overweight and obesity or obesity. This is too much, too many people. And this is not a single case. The Chilean case is not the only one, and it's not even the worst case of overweight and obesity. This is a challenge, a growing challenge that is affecting all developing and developed countries. It used to be a developed countries problem, but now it moves to countries that didn't have that nutrition problem. So the problem is we change our habits, we live differently. We don't have such physical activity as we should. We don't have time for healthy food. We don't have time to prepare food that our grandmothers usually prepare. So our health condition is being worsened due to the bad nutrition. And this is also affecting the number of deaths. If you see these numbers, the majority of the causes of death are related to bad nutrition, heart diseases, certain cancers, strokes, diabetes, but we pay too much attention to the homicide, which is in the bottom line of this chart. This is a question that raised Jamie Oliver in one TED presentation. So the biggest problems are not the biggest concern. And the challenge is in the future. If we see in the chart, this OCDE, the expected of obesity, it will be getting worse and worse. The United States will be reaching almost 50% of obesity, not overweight. And then it's Mexico. Chile is very, very near Mexico, then England, Canada. So developed countries and developing countries will face this huge challenge because of the bad nutrition. for excess. So it's called non-communicable diseases. And we also have the problem of food deserts. So in the cities, it's not that easy to find healthy food. So there's called food deserts. So that if you need and you want to buy good nutritional food, it's not easy to find on big cities. So we are living this pandemic, which is COVID-19, but also we have this bad synergy of previous pandemic, and this is called syndemic from Lancet publication. So we have 1 billion people suffering hunger, 2 billion people suffering overweight and obesity. We are suffering climate change, but we also now are facing another pandemic, and this fourth pandemic has a synergic and a negative synergic, and we're facing this syndemic. This is a challenge because they affect each other. So can we or should we apply certain restrictions to this kind of food and beverages? So what are ultra-processed food? They are high in energy, sodium, and saturated fat. This is they are low in nutrients. They are consumed in large portions, growing numbers. Easy access. It's very easy to find in a convenience store. They are very tasty. They are palatable. They have aggressive marketing. It's highly correlated consumption with overweight. So it's affecting our health. It's already proven. And it's increasing the incidence on percentage of calorie intake. So the daily intake is getting more and more percentage from the ultra-processed food. So our food that we're eating in this ultra-processed food has excesses, sugar, salt, sodium, calories, and saturated fat. So these nutrients are present in this kind of food. And it's hidden. Some of these nutrients, we don't know that by eating or drinking some food, we are having a lot of sugar, a lot of energy, and we don't even realize about that. So nutritionists has classified food pursuant to the ingredients. And they classify in this number 4 area. It's they divide ultra-processed food, and they consider that ultra-processed food are not food. And this is totally different, totally unexpected. What do you mean we are not eating food? What we are eating? We are eating some nutrients, some calories, some sugar, but you're not eating nutrients as we call food. So this should be taken in consideration for the regulation. There is scientific evidence of negative effect of this food. Yes, we have several publications that we gain and more overweight and obesity due to the nutrients that are present in this food. So what is the trend? We are eating this kind of food, ultra-processed food, with higher density, higher than before, higher than other types of food, and the percentage on the consumption of the families is getting more and more presence in relative terms of ultra-processed food. So we're intaking more and more calories from the ultra-processed food, who it's proven scientific evidence lack the best nutrients, and is increasing and worsen our health. So what should be the role of the law and the state facing this pandemic from the overweight and obesity that affected 2 billion people so far, and the trend will be worsened? Governments have tried many aspects: education, taxes, restrictions, advertising, physical activity, dietary guidelines, public health campaign, healthy food, and food labeling. And guess what? None of these really work. There is no scientific evidence that these several actions that several governments try, none of them are successful. So what about food labeling? There is a new trend of labeling. It's called FOP, front of package. And this is traffic light. One is more clear. It's in the front of the package. It's more visible, more easy for understanding for the consumers, and give you information of your nutrients. So this is the case of New Zealand. You can compare products for the number of stars. This is the case of France. So there are several alternatives. And this is the case of the Chilean law that gives you this very simplified format of labeling, and also includes certain restrictions for advertising and for selling in schools of this type of food. So this is a challenge, again, from the nutrition aspect, but now from the legal aspect, from international trade regulations. What can we do? This is in compliance of the current regulations, and guess what? Several countries are following, monitoring, and applying a similar format. Why? Because it's working. It's working, it's warning better, and it's making companies to adjust. And this is an unexpected consequences. So, like I said, the regulation also includes that you have to withdraw certain images on marketing, image of your product registered brands. The tiger, the animals in the cereals have to be withdrawn because they have this label. So it's affecting TRIPS agreement eventually. And the sales restriction to certain products that are considered toys, and they have the label, so they cannot be sold for kids under 14 years old. What happened? What companies has done? They adjust. They didn't like, they make lobby, but at the end they say, well, I don't want this negative label, black label, octagon in my products. So they withdraw the nutrition in order to be below the threshold. So that was, we create the incentive, and the companies move to the expected best trend. So this is the nutritional and the reality and the challenge. But what about the international trade commitments? Can we just overcome them? Can we just bridge them without considering? No, we cannot. So I'm not totally against the proposal of Professor Peter van den Bosche. I want them to fulfill, but we need to anticipate the crisis and not go below after the crisis. That may be one of the reasons of the problem, of the current problem at WTO. So there is existing regulation, SPS, TRIPS, TBT, Codex Alimentarius, and relevant jurisprudence. So I review, there is not exact regulation or interpretation on the panels or the appellate body related to this case, but there is some elements that we should take in consideration, such as legitimate objective of health protection, risk assessment, sufficient scientific evidence, and standard of review for local authorities, a measure not unnecessary or unjustified or excessive, and the less harmful possible alternative, the precautionary principle, and should be non-discriminatory nor arbitrary. So I review some of the jurisprudence that is, like I said, not exactly this point, but they are helpful to see how to interpret it. They highlight some relevant considerations that we should bear in mind for the future. An alternative measure which is significantly less restricted to trade. Do we have another alternative beside this black label, taking into account technical and economic feasibility and achieve members' appropriate level of sanitary or phytosanitary protection, considering the equivalence principle and transparency, also mentioned by Professor Peter van den Bosche. And there is another aspect, another treaty, which is TRIPS, because this regulation is affecting the brand names of the companies, the images they are registered, and they are private property from them. So this is, again, not the same, not similar, but tobacco is not a food. And if we consider ultra-processed as not food, maybe we should look tobacco as a possible alternative. So if requirements encumber the use of trademark in the course of trade are unjustified, so we should see whether this is meeting this standard or not, bearing in mind the legitimate interest of the trademark owners. So are those owners affected because they withdraw, they cannot use their images? The reason for the special requirements, and whether those reasons sufficiently support the encumbrances. In conclusion, So I'm sorry to be so fast, but this is as it's a little time. So again, bear in mind the pandemic, which is a syndemic pursuant to the medic publication Lancet. We have this growing percentage in income and in calories of the ultra-processed food because of the way we live today. Considering the nutritionist classification of food and non-food, if we accept the classification that ultra-processed food are not food, well, the treatment should be totally different. Maybe we should go to tobacco approach. Several cases show a trend of increasing calories intake and percentage of total diet. This is happening in the world. We are spending more and more money on ultra-processed food, and we are eating and getting more calories from those parts as a percentage. It's already proven in the world. So it must be assessed whether tobacco equivalent restrictions may apply to certain ultra-processed food. There are 16, some countries have tried taxes, sugar, Mexico, soft drinks, advertising, sales bans, and others. So can we accept this approach or not? Well, we should go to the basic and see what is the role of these agreements. Is to protect trade or to protect health also. So thank you very much for your attention, and look forward for the question.
Thank you very much for your intervention and presentation. Very, very, very timely, particularly when we are grappling with the issues of food security. But we oftentimes don't make the linkage between the trade of these goods and foods and the impact on people and everything. And the question therefore has to become, how do we do that in a sustainable way? And we're looking at offering these goods the highest quality and ensuring that our populations are not compromising their health whilst trying to obtain food security. In the advent of, for example, COVID-19, we've seen the disruptions in supply chains, and many times countries have had to resort to importing food or using food that may not necessarily be of the best quality or standards in that light. So very, very, very timely. We're now at the stage where we've all heard the panelists, and now we have our discussant, who is Lorenza Mola. And Ms. Mola is an associate professor of international law and a member of the board of the PhD in law, the individual and the market at the University of Turin Department of Law. She has a PhD in international economic law from Bocconi University and a master's in European studies from Université Libre de Bruxelles, and gained work experience at the Italian mission to the WTO and the European Commission DG Trade. So without any further ado, I introduce to you Lorenza Mola.
Thank you, Ambassador Blackman. Can you hear me?
Yes, loud and clear.
Thank you, and thank you to the organizers for having involved me in this very interesting conference with the role of discussant. So please allow me to stay close to my written notes, to stick to the time that has been given to me, which is 12 minutes, and hopefully a little bit less than that. So as everyone may well observe, this panel's title contains references to some of the UN Sustainable Development Goals, and the contributions which have been presented point to one or more Sustainable Development Goals. According to the call for papers, there is another arching idea behind this panel one of the calls, is that the international legal regime is called to achieve the goals of sustainable development, and to do so, it must develop new features which combine social environmental interests and trade economic interests. In the light of this idea, I would like to make some comments and raise some questions to the speakers on their very rich and stimulating presentations. My remarks and questions will be quite broad indeed, and mainly around the subjects and the sources that come into play when we think on how to reshape trade law for sustainable development. I will start with Daria. So Daria, your paper clearly identifies PP hands as the hinge between two treaty regimes, the Paris Agreement and WTO law. According to your analysis, accommodation of environmental interests and trade interests thus passes through the classical devices of treaty law, mainly lex specialis, coordination clauses, and especially interpretation. On interpretation, you argue, for example, that the criterion of consumer tastes and habits is fit to incorporate PPNs in the assessment of likeness. And you also consider this as the preferred gateway for environmental considerations into trade law. Well, I think that it results from your presentation that domestic consumers' choices and domestic policies from countries which have adhered to the Paris Agreement may have an extraterritorial impact, which overcomes a country's choice not to adhere to the Paris Agreement. My question to you then is whether you consider these treaty law devices adequate and enough to grasp the transboundary effects of pollution and climate change for the protection of the environment as a global common. And these few remarks on Daria's contribution lead me to indeed see these two contributions quite specular on sustainable production from their respective fields of scholarship. I further wonder whether the legal solutions they envisage can be considered complementary to each other, or whether stronger interaction between public and private law regimes should be welcome to accommodate environmental interests and trade interests in view of sustainability. So Christina, from your perspective, private actors are full legal subjects and they may be held liable, but you also stress the regulatory function of contract law. Your analysis presents interesting insights to me on the interaction between international institutions, or among, let's say, international institutions and private actors in the field of responsible production throughout the global value chains. So my question is the following. Do you see then private actors as delegates of international action on sustainability, given the fact that there are not international sources that directly bind individuals on these matters? And if I understood correctly, do you see a process line like the following one? So international institutions develop soft law instruments contemplating standards and codes of conduct for private actors. Private actors adhered to such standards by incorporating sustainability in their behavior and even in their contracts. And this in turn is able to prompt the formation of an inter-private source like usages, lex mercatoria. Moving to Luana's presentation, I think that Luana's presentation adds elements to this picture on subjects and sources for sustainable trade. It focuses on one single subject, the EU, and the variety of measures that are envisaged under the Green Deal. To keep it brief, I would like to observe that from your presentation too, it emerges that the EU Green Deal has an outward impact. So looking at this extraterritorial impact of the EU Green Deal, I noticed that you have in a way envisaged two mechanisms. One is that of obtaining commitments from third countries in the same areas addressed in the Green Deal, especially on the regulation of pesticides and antibiotics, but this has an indirect effect on producers in these third countries too. And the other mechanism addresses private actors, namely consumers and producers, quite directly. And I'm referring to the mechanism of labeling and incentives that are covered by referring to deforestation. But you also envisage a third way to expand the operation of sustainable trade measures, which passes through regional trade agreements. So my question, or rather my wish towards your presentation, is to to listen something more about the role of RTAs, regional trade agreements, how they can put stronger emphasis than the multilateral level to accommodate environmental trade interests. Well, in relation now to Nicholas, I found the concept of syndemic very, very interesting indeed. I propose to you and to all of us to reflect more generally on whether the Sustainable Development Goals themselves can provide somehow some grounds for legitimacy of measures that are adopted in order to pursue non-trade goals. I'm aware that this means that we must consider such broad issues like the legal nature of Sustainable Development Goals, and can Sustainable Development Goals come into relevance in the application of WTO law to domestic measures, and how would that be possible? Because of course this is not treaty law, so the kind of considerations we can develop with Daria's arguments and subject matters cannot be developed with Sustainable Development Goals. And so this is my broad reflection. And I think that this also applies to Amrita's analysis, although I noticed that Amrita's perspective is different from the others. You do not address the issue of compatibility of women empowering measures with WTO law, but rather see if and how international trade law can be supportive of women, especially in the context of the pandemic. Well, this goes in line with the recognition of an important role to play by trade in reaching development objectives, and this recognition is present in the UN Agenda for Sustainable Development. My question to you, Amrita, is about your point on the use of WTO law to boost women's capacity in the wake of the crisis, the pandemic, and in order to allow them to go out from this crisis period. But in light of the current situations, such as the one that has been described by Professor van der Bosch, how would you put the four fields of WTO law that you consider in your analysis in a scale of feasibility in the short, medium, and long run? And finally, Michael, thank you very much for having addressed the topic of innovation through cryptocurrencies. I'd love to listen to your impression and observations on the role of cryptocurrencies in the context of sustainable development, and consideration on how sustainability concerns may play a role in finding or arguing the best legal classification and the best legal regulation of this phenomenon, which is new and is continuously evolving. So these are my comments. Thank you so much for your attention.
Thank you very much, Lorenza, for your very broad remarks and perspectives with regards to the presentations that we would have heard. And you've also posed some very important questions to our panelists. Now, I'm acutely aware that we only have 15 minutes for the rest of this session. And I know there's another session immediately after. So what I'm going to do is to change up the format a little bit. And based on the questions that were posed by Lorenzo to our panelists, I would ask each panelist to treat to them within 2 minutes, maybe 2.5 at most. And then if we have time, we will take one from the chat where a number of participants may have asked questions, okay? So therefore, I will go perhaps in reverse order this time. And then I would invite Nicholas to give remarks to the question that would have been posed. So Nicholas, you have the floor.
Okay, thank you very much. Questions are related to transparency, nudging, food culture, necessity tests, sustainable goals. And the answer for all of them is yes, but it's based on the challenge we're facing. We're facing, remember the numbers of Chile. 3 in 4 people are facing problems of bad nutrition. 3 in 4. So is there any question that we need to review our industry food system, providing more transparency, but not only to the government, but to the companies and how and what are they producing and selling. And think about the food school programs. This is the funds are provided by governments, but the children are receiving this not necessarily good quality food. So it's, what is the challenge? What is the problem? Is we are facing, in a TED video, there is a person that says, we are the first generation in the history that will live less than the previous parents because of this food problem, bad nutrition problem. So this is the size of the problem. So facing this, we need to reconsider, reshape, not adding just inefficient protectionism, but review our food system and considering that we can create right incentives for the companies to adjust, as the black labeling, the food labeling system in Chile. The companies, Nestlé, adjust 2/3 of their products, and Coca-Cola. So the huge companies consider this situation, the challenge, and then just reduce and go below the threshold. So it was that simple. So I think, yes, we need to provide more transparency. We can use nudging, and Cass Sunstein from Harvard, he worked on that during the Obama administration. So the way you present the food to the children, and we need to consider other food system as traditional indigenous food and food culture, and try to protect that production because that is the right of food, access to produce or to buy. And finally, as Amrita asked, is this will be satisfy an eventual litigation process? I don't think so. I don't think it will meet because it's new, it's arguable, and it's not that clear the gray line. So, but I think we need to rethink this. I think it's not only about a litigation process, but the food system industry. So that would be my answer. Thank you very much.
Thank you very much, Nicholas, for that. We will now go then to Luana for your remarks to the questions that have been posed.
Thank you very much. Thank you for the questions. Starting with the extraterritoriality impact of the Green Deal, I would say that the EU is very aware of that and is actually looking forward to that. They do not shy away of saying that the objective is to use their power and influence political and economically to lead trade partners and also their own population, consumers, to change the behavior concerning sustainability. And it might sound naive from my side, but I think that the approach is much more that of carrots than of sticks. So what is happening right now is that the budget and everything that is concerning projects of development everything is also bound to the Green Deal and to sustainability. So now financing, granting, lending, every new project now has to have also an aspect concerning climate change. And in this sense, having the impact to, if they manage to get this impact and make other countries and also their consumers change their behavior, that's the goal. That's what they're aiming for. And for the RTAs, I would say that Professor Amrita Bari kind of already answered the question. What the RTAs can do, what the trade agreements can do, can change, is that they can be enforced. Enforcement is the major problem right now. They have great texts, they are saying beautiful things, they're not put into practice. So that's what needs to change. The Green Deal created the Chief Trade Enforcement Officer, so someone to look at it. They started work. It's a him. He started working a few months ago. Let's hope that soon we will have some impact of that. But if we don't put things into practice, if we don't implement, the trade by themselves will not change. Thank you very much.
Thank you very much, Luana, for your remarks. We now move to Dr. Barry for her intervention with regards to questions.
Thank you, Ambassador Blackman. Responding to the very first question Lorenza raised about the whole WTO compatibility issue, I am trying to explore that in respect of exception, Article 20A, to see whether members can possibly invoke the morality exception to protect their gender equality interest, especially in the post-pandemic world where countries may want to extend measures to support industries that would cater to women employees and women employers, as well as women consumers, I think, that are having a huge impact during this pandemic. So public morality is one way in which we can achieve compatibility. Writing this article with Professor Boklan, so it would be ready very soon, hopefully. And to respond to the second point, and also touching upon one of the questions that Laura has raised in the comment box about what about the viability of this proposal I'm trying to make during this pandemic, I think you're absolutely right. The concerns are very much legitimate because when we talk about the possibility of raising a gender exception, we are giving another way or another excuse of practicing protectionism to countries that might misuse this provision or such an exception, right? So how do we ensure that the misuse doesn't happen? Because it depends upon the way it's drafted, and member countries can try and draft it based on Article 20's drafting style if they want to make it hard for respondents to invoke, or they can go for Article 21 and then pretty much open it up for interpretation. But one thing is for sure now, we have seen that champions of change, for example, Canada, European Union, and certain East African countries are the pioneers of this change. They are increasingly more and more using their trade agreements for promoting gender equality concerns. And hope that they're able to use this card of trade agreements in the future and right after we have emerged from this pandemic, because this pandemic is reversing, it is undoing the gains we have made in respect of gender equality in the last few decades. So I think if there is ever a time, now is the time to think about how we can use these trade agreements. Thank you.
Thank you very much, Dr. Barry. We're now going to move to Daria to give her remarks to the questions.
Thank you very much, Ambassador Blackman. Thank you very much, Lorenzo, for your question. It goes in a very core of my paper. And my answer would be no. I think all WTO provisions I've analyzed, not only Article 20, are not enough to prevent transboundary harm. And I would say that even numerous provisions of environmental multilateral agreements, which are specifically focused on prevention of transboundary environmental harm, are not enough as well. And here I agree with Luana that it's a question of implementation, but not the wording of these beautiful provisions. And also specifically in respect to environmental transboundary harm, it is very specific due to at least two reasons. One is responsibility, because this harm is usually caused by actions which are not prohibited by international law. Therefore, all provisions on in the responsibility for international wrongful acts are not applicable. That is the first problem. And second problem, that common goods like environment as a whole, climate as a whole, atmosphere as a whole, there are no specific provisions with respect to responsibility of harming these common goods, because they are also of a kind of a specific nature. And even International Law Commission specifically underlined in their work on protection of atmosphere that they will not address responsibility for harm caused to common goods like the atmosphere. But on the other hand, I believe that specifically WTO provisions with respect to carbon taxes, carbon labeling, let's say carbon unfriendly investments, and exceptions under Article 20 B and G, they can be even more effective than some very good drafted but of a declaratory nature environmental provisions. Why? Because they are not solely environmental and social in a substance, but they can be used as economic incentives to the states to fulfill these obligations. My idea is that it is possible to use trade provisions as economic incentives to fulfill environmental protection goals, including combating climate change and protection of environment generally. So that is also the question of how to implement in this, using this approach, these WTO provisions. Thank you very much. That's it.
Excellent. Thank you very much, Dario. We'll now move to Christina. We have literally 0 minutes left, so we're going to take the final two remarks from Christina and Mikhail. Then I'll give my concluding remarks, and then I'll hand back over to our lead. So, Christina, you have the floor.
Okay, given time, I go straight to the point. Your question is basically, can multinationals be held liable because of the breach of SDGs, of the goals like environmental protection on behalf of suppliers? The question, no? How far can we go in considering multinationals liable for what is going on in the value chain? This is the question. So the answer is, it depends. If you have a case of corporate control, so it's a matter of parental liability, or if you have a chain that is managed by contract. No, and you have contracts for supplying contracts, sub-supplying contracts, and so on. So in case of parental control, you have the recent case Vedanta that a number of colleagues they work on that. No, it's about the duty of care of the multinational. Is a UK Supreme Court case about the parental responsibility of the multinational, a duty of care on behalf of suppliers because of the control that could be legally run or de facto control over the suppliers. So this is a good point. Or there is a different point, see control by contract. So if the multinational could be liable. We are discussing this point now. So there is no clear answer. There is an interesting point here in the sense there is this interaction with the public side of promoting SDGs. In the sense, what about the role of the state in pushing multinationals having registered office in the state in adopting sustainability in contracts, in codes? What's the role that the state can exercise? Take the case of Switzerland, for example, where there is this discussion that is going on that point. This is a case of complementarity between private and public. And this is a very good topic for future research. So thank you so much for your attention.
Thank you very much, Christina. And we now move to Mikhail.
It's mute.
Can you unmute it, or let's see if we can do it from participants?
Yes.
Yeah.
Oh, perfect.
It was only the host that could unmute me. That's why I couldn't unmute myself. So to be very brief, being conscious of the time, I think Lorenzo's question is absolutely pertinent, and I was hoping that a question like that could come up in the discussion. I have two very brief points given the time. The first point is that cryptocurrencies are energy heavy dependent. They require a lot of energy to be produced, and this is increasingly the case. So they raise a series of questions regarding the protection of the environment as well as sustainability. The second point, which relates to the policy reasons that I invoked in support of my argument that the World Trade Organization is the most appropriate forum for the regulation of cryptocurrencies, has to do with precisely the general exception clauses that they are contained in the General Agreement on Tariffs and Trade, Article 20, the famous Article 20 of GATT, as well as the equivalent provision in the General Agreement on Trade on Services. So again, from the perspective of sustainability as well, and concerns regarding the protection of the environment, and in the light of the fact that cryptocurrencies are energy intensive, the production of cryptocurrencies is energy intensive, the two agreements of the WTO, the GATT and the GATS, constitute the most appropriate framework for regulating cryptocurrencies, also from that perspective. Thank you very much again. Thank you.
Thank you very much, Mikhail. And let me say thanks to all of the panelists and also discussants and all of you who've logged on. Just a very brief wrapping up. A lot was discussed from different perspectives, but one thing has become very clear. In moving forward in terms of the sustainability agenda in the context of trade and trade law and also development, through the eyes of gender and innovation, there has to be more discussions like this, but equally, we have, how do we get the discussion from being merely one of theory into practice? That's going to be important if we're going to see these gains achieved. The law certainly has to be used as a tool and not as an end of itself to ensure that the sort of gains that we need will be realized, and more matrices ought to be built in. One of the things that I always say is that things have to be measured. How do we measure our laws to have critical impact? How do we get our legislators in Parliament or Congress across the world to be acutely aware of these things so that when they're passing laws, and equally when they're signing on to new treaties at the international level, that they're compatible with the realities that would have been described here this afternoon. So I really want to commend all of the panelists and our discussants for posing some very pointed questions to our panelists, and also again for the organizers for organizing what, to my mind, has been a very exciting and rewarding discussion. Certainly in my own personal capacity, I've learned so much more. I too have a legal background, and a lot of what you've mentioned today is really both, one, refreshing, and two, offers a new perspective. And certainly where possible, in my own capacity as ambassador in the WTO, I will be looking to use some of the techniques that you would have provided today on this discussion. So I really want to say thank you very, very much. And I wish the organizers a successful conference as you proceed. So thank you very much.